Good afternoon, everyone. This is the August 8th. This is not the August 8th. It's the September 12th Zoning Board of Adjustment regular meeting. My name is Matt Perry, and I'm chair of the board. I will now call this meeting to order and ask the clerk to call the roll so that we may verify the presence of quorum.
Can I go first? Board Member Callahan.
Here.
Eicholtz.
Here.
Grants-Korsch.
Here.
Hutchins is absent. Ingram.
Aye.
Johannesson.
Aye.
Perry.
Here.
Smikarova is absent. And Wing.
Here.
There are 7 members present.
Let the record show we have quorum. With that, we'll proceed to our agenda, a copy of which was posted for public access to the city's legislative information management system, available at lims.minneapolismn.gov. Is there a motion to approve this agenda?
Second.
It's moved and seconded. Is there any discussion? Hearing none, all in favor of the motion indicate by saying aye.
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 Aye. Any against indicate by saying nay. And that motion passes and the agenda is approved. Here's where August 8th comes in. I believe all the board members have seen a copy of the minutes from the August 8th, 2024 Zoning Board of Adjustment meeting. Is there a motion to approve?
Second.
Is there any discussion? Hearing none, all in favor of the motion indicate by saying aye.
Aye.
Abstain.
And one abstention. Any against? And the motion passes. The minutes from the Zoning Board of Adjustments August 8th, 2024 meeting are approved. Mr. Ellis, are there any petitions or communications?
No particular petitions or communications this evening, although I could do it at the end as well. Just reiterate that applications are open for all of the city's boards and commissions, and I encourage people to apply for the Board of Adjustment.
Yep. So if you didn't get that email, it shows who is up, what seats are up. So, and I would encourage you to reapply if you can. A reminder to applicants and others, if you're going to speak at the public hearing, please sign in on the sheet available from the clerk and speak clearly into the microphone. If you have not signed in, you can do so on your way out. Also to applicants and others, please contact staff after the hearing with any questions regarding your projects. And if you have something like this, could you turn it off or turn it on silent? I'd appreciate it. I'll read the agenda number and the address of the project and state whether it's slated for consent, continuance, withdrawal, return, or discussion. I'll just talk about discussion items here. These are items with which the board will take public testimony, deliberate on, and make a decision. After the public testimony has been heard for each particular discussion item, I will close the public hearing for that agenda item. Once I close the public hearing for an item, no additional public testimony will be taken, but staff may be asked to address board questions. After the public hearing for an item is closed, board members will then discuss and act on motions, and the chair only votes in the case of a tie. So agenda item number 5 is listed as a discussion item, but it is going to be requested to be continued to our September 26, 2024 meeting, and we can discuss this more when we review continuances. Agenda item number 6 is 208 Fifth Avenue Northeast. Staff is recommending this item for consent. Is there anyone who would like to speak against this item? Yes, please.
I just want to comment on this one that I was very impressed that the due diligence of looking at the impervious materials on this was done, because it looked to me like it was far too much impervious materials. And the requirement actually for this area is 85%, and I was very pleased to find out that it's underneath that at 79%. So just if the owners are here, I just hope that they will take that into consideration in the little green space that they have left, that they keep it fully pervious and make sure that their water can get through to there. So thank you.
Thank you, board member. Our next agenda item is number 7, 4441 Upton Avenue South. This item is also being recommended to be continued to our next meeting, September 26, 2024. We can discuss this more when we review continuances. And agenda item number 8 is 409 9th Street South, 1014 Hennepin Avenue, 1021 and 1025 Hawthorne Avenue, and this is a discussion item. So let's review the items on our agenda for consent. They are item number 6. Is there a motion to adopt this item on consent?
So moved.
Second.
It's moved and seconded. Is there any discussion on the motion? All in favor of the motion indicate by saying aye.
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 Any against indicate by saying nay. Any abstentions? There are none, so that motion passes. So if you are here for agenda item number 6, your land use request is approved. Good luck with your project. Thanks for coming down. Now on to continuances. The first one is 4917 Russell Avenue South. Can I get a report from staff on why this is being requested to be continued?
Chair Perry, board members, this request for continuance is occurring because the applicant has a meeting on site scheduled with the HVAC specialist to review the site conditions and possible changes to the HVAC equipment, and that is in next week. And so this will give us time to have that meeting and then review what, if any, variances would be necessary from that.
Very good. Are there any questions of staff? I see none. Thank you. So is there any discussion on that item? So I would entertain a motion to continue the land use request for 4917 Russell Avenue South to our September 26, 2024 meeting.
So moved. Second.
There's a motion and a second. Is there any discussion? Hearing none, all in favor of the motion indicate by saying aye.
Aye.
Any abstentions? Anyone against, say nay. That motion passes. And the application for 4917 Russell Avenue South is continued to our September 26, 2024 Zoning Board of Adjustment regular meeting. Our next continuance item is 4441 Upton Avenue South. Can I get a report from staff on this, on why the request is being made?
Chair Perry, members of the board, this item is being requested by the applicant to be continued one cycle to the September 26th Zoning Board of Adjustment meeting. This is to accommodate a scheduling conflict that staff was not aware of when the initial notices were sent out for this meeting. So typically, if we had known ahead of time, then we would have just scheduled it for the next meeting, but because the notices were sent for this meeting, we do have to formally go through the continuance process.
Sure. And we're okay on the clock?
Yes.
Okay, good. Any questions of staff? All right, so I would entertain a motion to continue this land use request for 4441 Upton Avenue South to our September 26, 2024 meeting.
So moved.
Is there a second?
Second.
There's a motion and a second. Is there any discussion on the motion? Hearing none, all in favor of the motion? Oh, I'm sorry.
He's had his hand up.
Yes.
Yeah, I'm here for that to meet for that. I won't be here at the next time. I'm a bordering neighbor.
Yep. I'm gonna give you an opportunity to talk if you'd like.
Today.
Yes.
Thank you.
Yep. But I'm glad you brought that to my attention. So all in favor of the motion indicate by saying aye.
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 Any against indicate by saying nay. Any abstentions? That motion passes. And the land use application for 4441 Upton Avenue South will be continued to the September 26, 2024 Zoning Board of Adjustment meeting. So, sir, if you'd like to speak today, you don't want to come down again on the 26th, you're welcome to speak today, and we can take your testimony now.
Okay.
And if you could give your name and address for the record, that would be great.
Thank you.
You're welcome.
My name is, can you hear me?
Yep.
Okay, my name is Michael Safir, and I am one of the 3 lots that border this property. And my side lot, even though they call it a rear lot for them, borders my side lot. And first of all, I was never sent any drawings or anything for this, so there's a lack of consideration in that regard. Secondly, the FAR requirement is hardship based, and I'm concerned that maximizing the profit and profitability of this house is being called a hardship. There's all kinds of houses that are smaller and multiple residences on that street that are smaller. And thirdly, it butts up to my side yard, which is 5 feet off a 7-foot tall retaining wall that's failing. There's been the drawings provided for this job ignored that entirely. They stop the line there. They don't show that it drops off, that there's a drop off beyond. And I'm wondering if it's all approved and this wall fails, who's going to repair that wall? So those are concerns I have. I think they're legitimate. I'm surrounded by starter castles. I've got 7 in every direction around my house. This is the last one, and I'd like to be a little assertive about what I end up looking at and what I end up paying for.
Okay. Thank you for coming down today and giving testimony. You don't have to do this, and your testimony today is recorded, but I would encourage you to also write down those bullet points and submit them to the clerk so that we can have them next time we meet on the 26th, just as a friendly reminder to us.
Okay. Thank you.
Thanks again for coming down.
Thank you.
Is there anyone else who would like to speak against or for this application to continue it? I see no one, so let's move on. And we are on to our first item for discussion, and this is agenda number 8, 40909 Street South, etc.
Chair Perry, board members, before you today is an appeal of the zoning administrator's decision that construction or structural alteration of any billboard within the Opportunity Billboard District requires provision of sign area credits, except on properties located in the Downtown East or Downtown West Entertainment Billboard Districts. And I will note, I will use the 2 words billboard and off-premise sign interchangeably. They mean the same thing. So the subject properties are at 409 9th Street South, 1014 Hennepin Avenue, 1021 Hawthorne Avenue, and 1025 Hawthorne Avenue. And each of these properties has a legal non-conforming off-premises sign. Orange Barrel Media submitted applications for buildings and sign permits to replace the existing legal non-conforming billboards on the subject properties. The replacement billboard structures were substantially similar in design to the existing structures in accordance with the provisions of the Minneapolis Code of Ordinances, Chapter 545, Article 6, Non-Conforming Uses and Structures. Staff approved the sign permits based on the legal non-conforming regulations without further examination of Chapter 560 as required by Chapter 545.910. The further regulations were accidentally neglected during staff's review, and legal non-conforming uses and structures may be continued provided such uses or structures are not expanded or intensified. However, Chapter 545.910 states in part, non-conforming off-premises advertising signs and billboards shall be regulated as specified in Chapter 560, signs notwithstanding the provisions of this chapter. Chapter 560 requires that in order to construct or structurally alter any off-premises sign within any Opportunity Billboard District, an applicant must provide or establish off-premises sign credits. This also applies for in-kind replacement of existing non-conforming billboards. Orange Barrel Media did not furnish the sign credits to erect the billboards at the requested locations. As soon as staff and the Community Planning and Economic Development Department realized this lack of compliance, they acted to rescind the issued permits. City regulators have an obligation and duty to enforce the code as written, even if there was an honest oversight. With that, staff's recommendation to the Zoning Board of Adjustment is to deny the appeal of the zoning administrator. That concludes my presentation. I'll also stand for questions, and the previous zoning administrator is also here if you have questions for him as well.
Okay, thank you. Questions of staff? I see none. And I'd just like to take a moment, if I can, thanks for your presentation, Mr. Willett, to say that appeals of the zoning administrator are not variances. They're also not a determination on whether to grant a non-conforming use certificate. The board's job is narrowly defined to determine whether the zoning administrator correctly interpreted and administered the current provisions of the zoning ordinance that are subject of the appeal. Furthermore, it's not the board's responsibility to determine whether the zoning ordinance is correct or should be changed. We are not a policy-making body. In appeals of the zoning administrator, we are also not charged with determining whether the efficacy of the city process is good or not good. And so I will open the public hearing and let the appellant speak first. If you could give your name and address for the record.
Thank you, Chair Perry. Scott Flaherty for appellant's address is 80 South 8th Street, Minneapolis. We're asking this body to grant the appeal over staff objection. The letter that purports to retract the approvals for the properties at this address is based on both legal and factual errors in a misreading of the ordinance today, a misreading that was not present when these permits were initially issued. I want to highlight a few important things from the staff report that we take exception to that we would like this body to pay special attention to. The second page of the staff report says in relevant part that as soon as the staff realized this purported lack of compliance, they acted to rescind the permits. That's not factually accurate. In the appeal papers, tab 8, to my letter, the appeal letter I submitted, explained and filed a copy of a November 2nd email where staff had chance to review this very question. They considered it. They, by their own description, discussed it with his superior, and they wrote, quote, this is a letter, email from staff, "We've confirmed that if your proposal was changed to reduce the size of the proposed sign to be the same or less as the square footage of the existing non-conforming sign, then no sign credits would be required for that." That was a correct interpretation of the ordinance as it existed then and as it exists now. The staff correctly understood in November of 2022 that sign credits weren't required. Ordinance Chapter 560 that this board just heard about governs signs, but the relevant portion of that ordinance is not discussed in the staff report. I'd encourage the board to look at 560.80 D1 and D2. D2 specifically discusses off-premises signs and maintenance and repair, which is defined to include replacement of off-premises signs. It says that maintenance and repair is allowed, period. If you compare that to 560.80 D1, it says it is subject to other requirements, which implicitly probably means the sign credits, but it means something else. Under the ordinance, repair, which includes replacement, is allowed, period. That's the correct interpretation of the ordinance, and that's the interpretation that staff and the director had in November of 2022. This reading of the ordinance also complies with state law. Nonconformities are property interests protected by state statute. That was laid out in my July letter, which formed the basis for the appeal. State law is not discussed in the staff report. And so before this body issues a decision on the staff report, I would encourage this body to consult with its attorney regarding state law or find some better understanding of why staff didn't analyze state law. Perhaps that's not its job, but state law does bind the city, even if in this particular instance staff didn't examine it. Now let's set aside state law for a minute. Page 5 of the staff report is not faithful to the language of the ordinance. Paragraph 5 of page 5 states that an applicant must provide or establish off-premises sign credits. But that's not actually what the ordinance says. The ordinance says that sign credits are required for the satisfaction of the zoning administrator. And here, probably for the reasons I stated earlier, in November of 2022, the zoning administrator was satisfied that sign credits were not required. That satisfaction is legally sufficient for these to issue. The staff report doesn't say he wasn't satisfied, and he was, so the issuance was lawful. And the fact that staff has a new interpretation of the ordinance now isn't a basis to revise or rescind those prior applicants. It's the zoning administrator's power and duty to issue these within his discretion and satisfaction, and there's not even an argument from staff that that satisfaction wasn't present back in November. So setting aside these legal and factual disagreements with the staff recommendation, I also want to end briefly by talking about public trust in the city and the process. Orange Barrel and these landlords did the right thing. They approached the city, they engaged with staff, they laid out their questions in detail, and gave staff the time to run the question up the flagpole before securing an answer in writing that sign credits weren't required. And the answer they got matches the language of the ordinance, so they proceeded. But now staff has a different story, and the staff report appears to be incomplete and inconsistent with state law. Public trust in the city is better served by vindicating Orange Barrel and these landlords. They did the right thing. They relied on what staff said. They're good public citizens. They want to beautify the city, improve the downtown, raise the tax base. Here, the fair and right thing is also what's legal, and so we ask that the appeal be granted, and I'm happy to take any questions.
Thanks for your presentation. Are there any questions of Mr. Flaherty? I see none.
Thank you, Chair.
Is there anyone else who would like to speak in favor of this appeal? Is there anyone who would like to speak against the appeal? Yes, sir.
Can I speak in favor of the appeal, please?
You want to speak in favor?
Yes.
Again, if you could give your name and address for the record.
Sure. Mr. Chair and members of the Board of Adjustment, for the record, my name is Dimpesh Darji. I stand before you today as the owner of 409 South 9th Street to address the July 3rd, 2024 determination made by the zoning administrator. Those determinations not only misinterpret the city's zoning code, but also pull the rug out from under me and other property owners who have acted in good faith based on permits issued by the city. There was a billboard on site that we relied upon when acquiring this property. The city previously approved and issued my company a permit to replace my existing sign with a new, slightly smaller sign. That permit was a green light, confirmation that I was operating within the law and zoning regulations. However, now, because apparently the city is being threatened with litigation by a prior sign operator, it's my understanding they're trying to rescind the very permit and associated approvals. That sudden reversal is not only unfair, but it undermines the trust that it clouds and undermines the trust that landowners should be able to place in the city's decisions. The timing of the city's actions is deeply concerning. It seems that rather than standing by its own interpretations and approvals, the city is caving to pressure from a sign operator who used to control the billboard in question. This operator is attempting to use legal maneuvers to maintain control, while the city, in an effort to shield itself from litigation, is trying to retract its legitimate approvals and revoke a lawful permit it already granted. This is not only unjust, but a violation of the basic principles of fairness. Beyond the legal chaos, there's a critical issue of fairness and equity. The city's current stance suggests that the right for this sign to exist upon my property belongs to the operator, not me. This interpretation strips me of my ability to negotiate fair market terms for my property, locking me into a perpetual and unjust relationship with the previous operator. As a result, I would be forced to accept whatever terms they dictate or risk losing the revenue source entirely, terms that undermine the value of my property and violate my rights. The city's decision not only harms me financially, but also establishes an unfair precedent for all landowners in the city. I am being penalized for doing everything by the book, while the city, under pressure from legal threats, is essentially allowing a sign operator to dictate the terms of my property. This inequitable situation must not stand. I urge you to reconsider the city's flip-flop in determination. The city must uphold its original approvals and permits and not facilitate landowners being victims of legal bullying by powerful operators. Let's restore fairness, property protection rights, and allow landowners to maintain their trust in the city's decisions. Thank you.
You're welcome. Thanks for your testimony.
Yep.
Anyone else want to speak in favor? Sure. Name and address for the record, please.
Ryan Thompson, 1022 Hennepin Avenue. Mr. Chair and members of the Board of Adjustment, for the record, my name is Ryan Thompson. As the owner of the Orpheum Lot, or 1022 Hennepin Avenue, I'm here today to address the zoning administrator's July 3rd, 2024 determinations. Those determinations are more than just legal errors and missteps. They represent a situation where the city is pulling the rug from under me and other property owners. After issuing me a permit to replace legal non-conforming signs on my lot with new signs of the same size and dimension, the city is now attempting to rescind its approval of those permits, all because they're being threatened by the previous sign operator. This sudden reversal is not just shocking, it's unjust. I followed the city's rules and obtained all necessary approvals and permits, understanding that I had the legal right to replace the signs. But now, in the face of a potential lawsuit from the former sign operator, the city is trying to undo what it's already approved. This action is unfair and undermines the trust that any property owner should be able to have in their city's processes. Let's be clear, the city is not acting because I did something wrong, but because it is being pressured by a former sign operator who is trying to regain control of signs on my property. Instead of defending its legitimate approvals, the city is trying to reverse counsel to avoid a legal fight. This isn't about zoning or the public good. It's about the city protecting itself at the expense of law-abiding property owners like myself. What makes the situation even worse is the impact it has on landowners' rights. By taking this stance, the city is essentially saying that the right for these signs to exist on my property belongs to the prior operator and not me. This would leave me and others in similar situations trapped in unfair, long-term relationships with unwanted sign operators, unable to negotiate better rental terms or make improvements to our properties. The result is an unfair and inequitable situation where sign operators are allowed to dictate the terms of my property while I am left with no recourse. Worse still, this decision discourages investment in the city's downtown. Landowners like myself want to invest in our properties, make necessary improvements, and contribute to the revitalization of downtown, but the city's actions make that impossible. This decision deprives property owners from holding sign operators accountable for maintaining signs in the city and ultimately threatens the viability of downtown Minneapolis. I ask you today to stand with property owners and reject these erroneous new determinations made by the city this past July. The city must honor its approvals and permits it issued to protect landowners from legal manipulation by sign operators. Let's ensure fairness and promote investing in a thriving, beautiful downtown. Thank you.
Thanks for your testimony. Anyone else want to speak in favor of the appeal? Anyone want to speak against? Name and address, please.
Sure. Good evening, Chair, Board. My name is Matthew Weiland with Clear Channel Outdoor. We operate billboards in the city. We office at 3225 Spring Street, Northeast.
Can I get your last name again?
Weiland.
Wyland, okay.
Just a few comments and clarifications. It's certainly been applied tonight. There's threats being made at the city by an operator such as ourselves, which is untrue. Sorry. It's been applied tonight. There's threats being made at the city from an outside operator, which is untrue. What we've asked for is clarification. And all we're asking tonight and all we've ever asked the city is just to uphold and enforce their ordinances as they've had, as we've abided by. The issue before you tonight is an issue of sign credits. Whether they had them or not is what staff is saying. The other topic that's come up by the appellants is the non-conforming rights. And that is a whole different situation. And it's been determined by this board before that in the case of billboards, those non-conforming rights belong to the sign owner. That's why there's a sign credit program. We can take down those sign credits, and that's how we establish new credits. But that's been a long-standing way that the city's operated. And all we're asking for is the city to continue to fairly enforce their ordinances. That's all we're asking for. And that's all we requested of staff was clarification on what's happened here, because this has never happened before in the past because non-conforming sign rights. And again, what's different here is these are non-conforming signs. Any other place you want to go build a new sign in the city, anyone can do so. In certain areas, you need to have sign credits. It's been a long-standing partnership between sign companies in the city that we take down signs in older areas, less traveled areas, in exchange for consolidating them in entertainment districts along freeways. It's a way we've removed hundreds and hundreds of signs to get to this point, and it's been a great partnership. So again, the issue tonight before you is of the sign credits, and certainly we support staff's position and how they came to that determination, and that's how we've operated our business for the entirety that we've been here, is in accordance with your current code. Thank you.
Thanks for your testimony. Anyone else want to speak against? I see no one. I'm going to keep the public hearing open, and I'd like to have Mr. Poor address a couple of questions if he could.
Good afternoon, Chair Perry. Steve Poor, City of Minneapolis.
Yep. So is it a requirement of the city to require these sign credits? That's, I think, part of the nub here. Someone made a mistake, clearly, at some point. And what I'm wondering is there like a 60-day clock on this? Or is it something that the city has to rectify and is just doing as a matter of practice?
At this particular location, there is a requirement to use sign credits that companies have acquired by removing non-conforming signs in those locations. So these permits went out without that happening. I don't think I'm not ready to opine on a 60-day question. I think I'd leave that for others and the city attorney. But real quick, the so-called cap and replace system was put in place to remove non-conforming signs from other parts of the city. That entitled you to build either in most of downtown or along the highways. And the whole premise is, if you had a non-conforming sign, you removed it, another one wasn't going back there. It would undermine the incentive to the program. And that program is, I think it was devised in '94, so it's been around for some time. And so at this location, even though there's existing signs there, if somebody wanted to put a new sign there, the sign company that had the sign takes it down, a new company could go into that location if it was qualifying for all other aspects of the ordinance, spacing, the right zoning, lot width, things like that. But then they would need to utilize credits to build a new sign as if a sign was never there. That did not happen in this case. It came to, as some of you are aware on here, I was serving as the zoning administrator. I think the last act I did was having my signature on that letter that went out to the Orange Barrel folks. I don't have that role anymore. So at some point in the transition, maybe there was some training issues, if you will, around the program. And so there was a mistake by staff. Our obligation is not to bend at the threats of lawsuits, but if we see that we made a mistake, we have to rectify it. This is a particularly difficult one to do, given the circumstances, and we are sensitive to the property owners who feel, have feelings about that this isn't right or it's unfair. That's not our job. Our job is to enforce the ordinance, to uphold the ordinance. When we find a mistake, we have to redress that mistake, and that's what brings us here. The appellants disagree with that, and they filed an appeal.
So can you speak to the state law issue that the attorney brought up?
Yeah, the city has its own set of rules. The non-conforming, we believe our ordinance is in compliance with the State Planning Act. It doesn't supersede the requirement to have credits in this instance. So they can make the point, but it doesn't supersede the ordinance as written.
Okay. All right. Does anybody have any questions of Mr. Poor? I don't see any. Thanks.
Great, thank you.
Okay. So I am now going to close the public hearing. Board comment? Yes.
Thanks, Chair Perry. I'm going to stand and support staff findings in this instance.
Okay. Thanks for your comments. Yes?
I'm still very confused because I really dislike being in a public body where the words public trust and upholding the original intentions are bandied about. And I am also concerned with the last comment there that mistakes are made and that we just have to still go by the regulations when there's significant financial complications due to this change and to this mistake. So I am troubled, and I don't like the word that public trust that has been done. So I don't even know who to ask the question to, but if this appeal goes, if this is denied, my question is there any way that there is an appeal process? Because this is not an appeal process, correct?
This is an appeal.
Pardon?
This is an appeal of the zoning administrator.
Of the zoning administrators, correct. But
and if our decision is not liked by someone, either party, they can appeal that to the city council.
Okay, so they can't, okay.
There is an appeal process.
There still is an appeal process
Yep.
to the city council?
Mhm.
Okay. Yeah, all right. I'm not in agreement, I guess, at this point.
Okay, anyone else? With that, I would entertain a motion.
I would make a motion to adopt staff findings.
There's a motion to adopt staff findings and deny the appeal. Is there a second?
Second.
There's a second. Any further discussion on this? Yes, Mr. Ingram.
I'll just add that I think the situation sucks in a lot of ways, but we are not in charge of fixing mistakes. We have what's in front of us, and unfortunately, I think that's why I agree with Member Johannesson.
Thanks for those comments. Anyone else? Yes.
While I agree with some of the other comments that have been made, I also want to echo something that Grant Skorsh already mentioned around it is troubling to be part of a board where there's conversations of lack of public trust. And so I think while I agree with staff findings in this case, I also want to uplift and echo something that another member of this body had already mentioned.
Thanks for those comments. Anyone else? Seeing none, we have a valid motion before us. Will the clerk please call the roll?
Board Member Callahan?
Aye.
Eicholtz?
Aye.
Grant Skorsh? Hutchins is absent. Ingram?
Aye.
Johannesson?
Aye.
Smikarova is absent. And Wang?
Aye.
There are 5 ayes.
So the appeal is denied. You can talk to, actually, you've already heard and probably are aware of what your options are, but you can talk to staff what your options are going forward. Thanks for coming down and making your case. Let's see, is there any new or old business? There is not. Our next meeting is on the 26th of September, and with that, I would entertain a motion to adjourn.
So moved.
Second.
It's moved and seconded. All in favor indicate by saying aye.
Aye.
We are adjourned.